I'm Wendy Sellers, the HR lady. We are here today to talk about a hot topic that's in the news in case you have been listening to the news, or some cases you might be avoiding it, but it is disparate impact. So we have here today with us David Miklas, who is an employment attorney. Hi, David. How you doing?
Great. Thanks for having me.
Absolutely. I'm going to go ahead and get our PowerPoint started and turn off this video of mine just so I can manage our attendees and not distract everybody. So with that said, give me 1 second here to share our PowerPoint and then we'll get started. And for those that are coming in late, I will make sure that I'm checking on your status. We will be recording this and putting it on YouTube as well. So check on my YouTube channel. I'll send out a link afterwards. With that said, disparate impact, such a hot topic. I just can't even believe what a hot topic it's become. And I had no idea that this was going to be this way. So it is definitely very interesting of what is going on in the world right now, and what is going on in the politics in the United States. I'm having some technical difficulties here, but I'm going to go ahead and turn this over to David Miklas. David, you want to talk a little bit about yourself and what type of businesses you work with?
Sure. So I'm an employment attorney. I only represent Florida employers. I help businesses, nonprofits, public sector employers like cities, county school districts. I've been doing this for 26 years.
Wow. You and I, our careers are very similar, I believe, in the length of time. I am an HR consultant, and I help as many employers as possible. Although I do live in Florida, I work with companies all over the world, mostly in the United States. And I have to tell you, when I have any employment related issues, David is the person that I go to because I feel like as HR or people that are wearing the HR hat, they expect us to be lawyers and we're not. That's not what we went to school for. And so trust me, there's a few times I thought maybe I should go get my law degree, but I then realized I have enough student loans. So we'll kind of end up referring to people like you. So let's go ahead and jump in, David, on this very, hot topic that's in the news. And can you explain to our listeners, what is disparate impact and disparate treatment?
Sure. And this is all coming in the news because of what President Trump did recently. On April 23rd, President Trump issued a new executive order, and it's called Restoring Equality of Opportunity and Meritocracy. And that executive order targets Title VI and Title VII of the Civil Rights Act. And I'm going to focus on Title VII. Now, the executive order states in part that it is the policy of the United States to eliminate the use of disparate impact liability in all contexts to the maximum degree possible. Now, I think I can explain an overview of this area of the law in maybe 5 or 6 minutes. In general, Title VII, uh, under Title VII, an employer may be found liable for unlawful discrimination under any one of three discrete theories. One is pattern and practice discrimination. Another theory is disparate treatment. And the third theory is disparate impact discrimination. Now, two of these require proof of discriminatory intent. The pattern and practice theory does require intent, and disparate treatment claims also require proof of discriminatory intent. And disparate impact claims do not. And disparate impact is sometimes referred to as adverse impact, whereas disparate treatment is sometimes referred to as adverse treatment. So if you read different things, you may see it written one way in one location or in a case, and a different way in a different one. But it's the same thing. Adverse impact is the same thing as disparate impact. So let's talk about intent just for a second. What is intent? As an example, in a disparate treatment case based on sex discrimination, the employee bears the ultimate burden of proving that the employment action at issue was taken because of the employee's sex. Now, let's talk about the other type of liability that requires intent, pattern and practice. In a pattern and practice case, the employee must prove, normally through a combination of either statistics or anecdotes, that the discrimination is the company's standard operating procedure. Now, different from those two theories is disparate impact. The disparate impact theory, on the other hand, prohibits neutral employment practices, which, while non-discriminatory on their face, essentially visit an adverse, disproportionate impact on some statutorily protected group. Now, this is not some creation from President Biden or President Obama that Trump is trying to undo. Title VII prescribes not only overt discrimination, but also practices that are fair in form but discriminatory in operation. Now, that language, it's not mine. That sentence actually is a quote from a 1971 Supreme Court decision called Griggs versus Duke Power Company. And this is it's only this last group, the disparate impact group, is what the executive order will impact. Now, the doctrine of disparate impact discrimination seeks the removal of employment obstacles not required by business necessity, which create built-in headwinds and essentially freeze out protected groups from job opportunities and advancement. And the premise of disparate impact theory is that some employment practices adopted without a deliberate and discriminatory motive may be the functional equivalent of intentional discrimination. Now, there is a case in the year 2000 in Florida called Joe's Stone Crab, and it went up to the 11th Circuit Court of Appeals. And that appellate court is controlling in Florida, Georgia, and Alabama. And they explained that disparate impact theory is a doctrinal surrogate. That's the language they use. It's a doctrinal surrogate for eliminating unprovable acts of intentional discrimination hidden innocuously behind facially neutral policies or practices. So the disparate impact framework under Title VII by now is well established. So since the 1971 Supreme Court decision in Griggs, Congress has codified the appropriate burdens of proof in these cases, what the employer has to prove, what the employee has to prove, and that really is well established. Now, this recent executive order by President Trump directs the Department of Justice and the EEOC, the Equal Employment Opportunity Commission, to what's called deprioritize enforcement of all laws and regulations to the extent that they include disparate impact liability, such as those under Title VII. So the executive order specifically says that this is due to limited enforcement resources of executive departments and agencies. So what this means is that prior to June 6th, the chair of the EEOC will review all pending investigations and all EEOC lawsuits which are based on disparate impact theory under Title VII of the Civil Rights Act, and she will drop those lawsuits and not issue a cause finding at the investigative level. Now, this is not really going to open the floodgates and have employers brainstorming ideas on how they can engage in disparate impact discrimination against protected categories such as Black people. This is, focusing on the deprioritizing the enforcement. And every agency does that. Doesn't matter what the president is. They pick and choose what things they're going to focus on. And the other things could still be illegal, just that the agency is not going to focus on it.
Mm. Wow, that's a lot of legal terminology there for us to know in HR. And so, I mean, the news then is probably making it a little bit worse than it actually is. But, my question, my next question is, I hear things about the 80% rule. What the heck is this, and how is this being affected with this political information in the news?
Okay, yeah. And this gets into a little bit of math, and I'm not going to bore your listeners talking about math for 15 minutes, so I'll just talk about it for probably 1 minute. But basically, the 80% rule is also known as the 4/5 rule, and it's a guideline that's used mainly by agencies to assess whether a selection process may have a discriminatory impact on a protected group. And basically, it suggests that a selection rate for any protected group should be at least 80% of the selection rate for the most favored group in order to avoid a potential claim of adverse impact. So if the selection rate for a group is less than 80% of the highest rate, it may trigger further investigation into potential discrimination. And that's what the EEOC used to do prior to this executive order, where they would spend some of their time and money focusing on this disparate impact. And now they're not going to. Doesn't mean that it's not illegal anymore. And the 80% rule is still a good way to determine it. And you could do that internally. And you do need to get into a little math. And since we're on a webinar and even a podcast, there is a detailed, probably about a 10-page article available on the SHRM website. And I think you've linked it in the notes here, but I would encourage the readers to read it. The article is called Avoiding Adverse Impact in Employment Practices. And basically that article will get into the math for you.
Okay, excellent. Yeah, everybody who's online, I will be sending out a copy of this slide deck to you. And there is a link to that SHRM article at the end on the resources slide. So that is very, very important. It's a small article, but then there's hyperlinks in there, avoiding adverse impact in employment. Can you provide an example of like a scenario where disparate impact has been a concern for an employer, a legit concern, and what steps, our listeners might take to mitigate risks?
Yeah, and people need to understand that disparate impact discrimination is still illegal. And an employer can be sued by an employee or even an applicant for, under that theory. And that theory of discrimination has always been harder to prove. And it's not really the desired pathway to sue because you have to get into the math. You have to look at statistics, and a lot of times it may be difficult to have that information and even to get it through discovery. And sometimes employers see this where they have a RIF, a reduction in force, and they get to pick who they're laying off. And it turns out that all the old people are adversely impacted. So now, given the limited enforcement of the EEOC will begin to what they call deprioritize enforcement of those kind of cases, the disparate impact liability cases, and that will allow them to spend their resources in other areas. So we're probably going to see an increase in enforcement of disparate treatment claims, the intentional discrimination claims. And in fact, just a couple days ago, on May 20th, the acting chair of the EEOC just issued a press release in which he stated that the recent executive order from the president directed all agencies, including the EEOC, to deprioritize disparate impact enforcement through the investigations and lawsuits. And she reminded employers, this is important, that the EEOC is an executive branch agency, not an independent agency. As such, the EEOC will be robustly complying with the executive order, which means that the EEOC will prioritize remedying intentional discrimination claims. And she also added that under existing law, the fact that a neutral employment policy or practice has an unequal outcome on employees of a particular race or sex, that is disparate impact, does not justify your company or your organization treating any of your employees differently based on their race or sex. Just the EEOC is not going to be pursuing these things because they're going to shift their focus elsewhere, but this stuff will still violate the law.
Right. So an employee, if there actually is disparate impact and it could be proven, then an employee can still hire an attorney and sue the employer. It won't go through the
Yes,
EEOC, correct?
correct.
All right.
Or even if they file a charge with the EEOC and the EEOC doesn't find cause, the employee is always going to have a right to sue letter, which will let them go into court and sue on their own.
Gotcha. Absolutely. Okay. So this has been amazing information because I think, of course, we get things in the news and then the media needs to spin things and they're making it sound like disparate impact went away, and that's not the case at all.
Correct. And I think now would be a good time for me to give you a couple example situations where maybe a small business might unknowingly violate disparate impact rules. Does that sound good to you?
Absolutely. Thank you.
Okay. So a business might be wondering, hey, what are some examples of disparate impact? Well, we'd have to look at what are neutral policies that the business has. And some examples of neutral policies with the disparate impact could be the following. A policy that says no outside food. That kind of policy may exclude people with diabetes who need to eat frequently to control their glucose level. Another example could be a policy that says no motorized devices. And that may exclude people with disabilities who use a wheelchair or electric scooters. Another example could be where an employer has a policy to disqualify applicants based on criminal history. Now, anyone that, you know, does that probably should be aware that there's a Supreme Court case called Green versus Missouri Pacific Railroad Company, and that essentially set up the green factors. And it's available on the EEOC website. Just look up convictions, green factors, and it tells you what you need to analyze before you exclude applicants based on criminal history. So, and the reason is because an employer's policy, if you had that kind of policy, it could have a disparate impact on mainly black people. And in that case, in the actual case itself, they did the statistics, and that's what these cases are driven on. And they said, hey, you know what? 5% of the black applicants were affected, and only 2% of the white applicants were rejected because of their conviction records. And when you do the math, at 80%, that kicks in. So also, an employer relying on an applicant's prior pay and setting their salary, that can be facially neutral. Doesn't say, hey, we're going to pay women less. It's just, hey, well, we'll pay what you got paid elsewhere. So that could be a facially neutral policy, but that can have a disparate impact, mainly on female applicants who may have been traditionally paid less than men, for many years. So this is what we're talking about when we talk about a facially neutral policy that may inadvertently, not intentionally, but it could still have an adverse impact on a protected category.
Wow. So this is a way more than just about, skin color, correct, and race.
Yep, yep. Any of those protected categories, like with the RIF, we see it with old people. When I say old, I'm talking about anyone that's 40 or older can sue under the Age Discrimination and Employment Act. And if you have a RIF, and let's say you're picking and choosing who you're letting go, and it turns out that maybe 8 out of the 10 people that you're letting go are in their 50s and 60s. Even if you're picking and choosing, hey, okay, anyone who makes more than $50,000 a year, we're going to cut them. Well, the longer that you're at the job, you tend to make more money. But look, if you're letting 8 out of 10 people go that are in their 50s and 60s, that probably is going to have an adverse impact on based on age. So I think that you could open yourself up to an age discrimination claim.
So two things. Number one is to make sure that if you are doing any changes in your head count, for example, because I know a lot of people right now are looking at their head count and possibly doing layoffs and reducing expenses, so to speak. Not that I want to call people expenses, but make sure that you're getting an expert involved, maybe even have an employment attorney or an external HR consultant look over your information. I know myself, during the COVID period, I was unfortunately helping clients lay off. And when I started doing the analysis, we both, myself and the small business owner on a high level, looked at the spreadsheet and was like, whoa, we are having disparate impact right now and it was on certain races, because just like you said, we were choosing based off of money. And so that was very interesting, even for me, the HR lady.
Yeah, and,
Uh,
and it's good that you mentioned looking at this spreadsheet because that's what you have to do. You have to look at something, and if you don't, you're like, hey, we're just gonna let go the last 20 people hired, and think that okay, that's fair. It's not all the black people, not all the women, But when you look at it, you have to compare it against, well, what does this look like? And if you're let's say you're giving a severance agreement to a bunch of people, well, the law says under the Older Worker Benefit Protection Act, if you're giving a severance agreement to, a group of people and anyone in that group is 40 or older, then there's extra things you have to do if you're going to ask them to waive their right to sue you for age discrimination. You have to give them a time period. Normally it's 21 days, but expands it into 45 days if it's a group and it includes old people. And also you have to give them a breakdown of which departments you selected, which people, their ages. That's exactly the reason. And so you can see, does it look like you're just getting rid of the old people? And that's the same kind of breakdown that you should be doing if you're, doing any kind of RIF. and don't just limit it to ages. You should look, okay, is this all the white people in the company? Is this all the black people, all the Hispanics in the company? Is this, certain genders that are affected, disproportionately, or even religions? Are we getting rid of all the Muslim people all of a sudden? Those are the kinds of things that certainly can be impacted, like during a rift. But it's not just rifts, but that's the one that we've been talking about here.
Yeah, absolutely, because of what's going on in the economy. And it really is, it's a little scary because I know many executives will say, but that's not the reason we chose them. And like, well, we don't really care. Please don't tell your executives we don't care. But you have to really show them the facts. Here's the law. Here's the decisions that we're making, and these decisions that we're attempting to make are, conflicting with the law. So we need to make different decisions. And so
Yeah,
it doesn't
and
always make sense, right?
no, but
But
Wendy,
we have to follow the law.
yeah, but it's important, like for the managers to understand this is how we defend.
Right.
If we're ever challenged later on, how do we defend? We have to be able to go back and prove, well, this is what we did at the time. This is how we made these decisions, and we even took this extra step to make sure that it wasn't unfairly impacting, any protected class, any disparate impact. That's really what the goal is that you should be doing for a RIF, but it can affect other things too.
A little quick side note here. David and I both fall in the old people category, so
Yes.
please don't get offended that we're calling you anybody over 40 old. It's just kind of, common language. Don't call your employees over 40 old.
No.
But little side note there. And then the second thing that I just briefly wanted to mention, since we have people all over the country on today, is David, are there specific laws that we're talking about right now is the federal law on disparate
Yes.
impact. And there are laws in many states that may be associated with this where you still have to comply with those, correct?
Absolutely. And there's, obviously 50 states, but there could be different city ordinances or county ordinances that can come into play. Obviously, I can't possibly be aware of every single one across the whole country. So you and I are just been talking about federal law. But if you're in a state that has a lot of, state enacted legislation also, it probably is going to be even more protective for the employee. Very rarely is it more protective for the business. It's usually more protective for the employee. So, your mileage will vary. You have to look at your own state laws to see if there's any extra steps you have to take in your specific state.
Absolutely. Awesome. Thank you so much for this. I think this has been incredibly helpful at this point in time. If anybody does have any questions, feel free to put it in the chat right now. Otherwise, I just sent you an email or a message through the chat that you can just email me directly if you have any questions.
Wendy,
Um,
can I just talk about one more thing real
sure,
quick? Waiting.
absolutely.
Okay, I'm just going to mention this maybe while we're waiting for comments, but my advice would be to always be careful when relying on a workplace rule to say no to an employee accommodation request. So, for example, you may have a facially neutral policy, like no hats or no headwear, a policy that bans all hats or wearing anything on the head. Now, that policy is facially neutral because it applies to everyone. It doesn't say no do-rags or bonnets, which are worn by many blacks to protect their hairstyle. So the policy itself, that says no headwear, that would be facially neutral. It doesn't on its face discriminate. Like a policy that if it said no yarmulkes, yeah, that on its face would discriminate. But the facially neutral policy of no headwear can have an adverse impact on Jews who want to wear a yarmulke or Muslims who want to wear a hijab, for religious reasons. Also, a policy that says no dreadlocks probably would impact black people more than white people. Not necessarily, but probably when you look at the statistics, it probably would. So need to be careful if that's the kind of policy you want to have. Also, a no beard policy or a headwear policy, both of those would be facially neutral, but they probably would impact religious people more. So, same thing with the no dreadlock policy. It's neutral, but probably more harshly impacts black people than white people. So these are the things, that may not be targeted right now in the next couple years by the EEOC, but still could result in legal exposure.
Wow. Yeah, that's a lot. That's a lot of information to consider Like I said in the beginning, when we enter HR, somebody hands us the HR hat. We're like, you know what? I probably should just got a law degree here, but we need both of us. We need both of us. I mean, I know you and I work together often.
Hmm.
Again, everybody remember that depending on what state you're calling in from or where your employees are located, even if you just have one employee, remote or not, in some other state, you need to look up the laws of those states as well, because there may be laws related to disparate impact or disparate treatment, so on and so forth. But if you do have any questions, I first of all, I encourage you to connect with David on LinkedIn. He's very, very active on there. His information is right here, David Miklas, and then his LinkedIn is here as well. And I will be sending this out to everyone. I also encourage you to connect with me on my podcast. I have had two podcasts and we just merged them together, HR Empowerment Podcast. And if you do listen to the HR Empowerment Podcast through the HR Empowerment website, which is Aurora Training Advantage, you actually get Sherman HRCI credits. So check that out, completely free. You don't even need to be a member. And then last things that I did want to say is obviously I'm an HR consultant. I have a learning management system if you're interested in that. It's very, very affordable. We have recruiting services and we just added resume review. So I have a marketing and writing expert who is rewriting folks' resumes, unfortunately, because so many people are being laid off. With that said, David, any final words before we wrap up?
No, no, I appreciate doing this webinar, and I know in the past you and I have shared the stage, and I know in the future we look to forward to possibly providing live in-person training together. And I think this is a great platform today. I can't believe you're giving this away for free. I hope the people
Yeah.
enjoy it.
Yeah, absolutely. I tend to give some things away from free, and my marketing person who's on LightNet right now wants to strangle me. But I think we're all in this world together and we should help each other. So if you have any questions whatsoever, folks, just let me know. Other than that, I will send this out to you shortly. Take care, David. Thank you so much. This is
Sure, thank you.
so appreciative and way more information that I even thought was going to occur. So take care, everybody, and have a great week.